Welcome to our examination of civil liberties in the American legal system. Civil liberties are individual liberties established in the Constitution and safeguarded by states and federal courts. We also refer to civil liberties as personal freedoms and often use the concept of liberty and freedom interchangeably. Civil liberties differ from civil rights. Please make that distinction in your notes. Civil liberties are constitutionally established guarantees that protect citizens' opinions and property against arbitrary government interference. In contrast, civil rights reflect positive acts of government in the form of constitutional provisions or statutes for the purpose of protecting individuals against arbitrary or discriminatory actions. For example, the freedom of speech, a liberty established in the First Amendment to the U.S. Constitution, protects citizens against the government's censorship for their words, in particular when those words are politically charged. In contrast, the constitutionally protected right to vote requires the government to step in to ensure that all citizens be allowed to vote, without restriction by individuals, groups, or government officials. The U.S. Constitution, through the Bill of Rights, and state constitutions explicitly recognize and protect civil liberties. As you can see from this chart, the first 10 amendments to the Constitution explicitly limit the power of the legislative, executive, and judicial branches of the national government. The Bill of Rights established the freedoms that are essential to individuals and groups' free and effective participation in the larger community. Consider how the absence of freedom to speak one's mind or the absence of protection against the arbitrary exercise of police powers might affect the nature and the extent of people's engagement in political and community debates and discussions. Without these protections, citizens could not freely express their opinions through rallies, speeches, protests, letters, pamphlets, public meetings, blogs, email, and other forms of civic engagement. The Constitution's framers, who had been denied these liberties under British rule, saw them as indispensable to forming a new democratic republic. The means of these precious freedoms have shifted over the course of U.S. history. As presidents, legislators, judges, and ordinary citizens have changed their minds about how much freedom the people should have. When Americans have not perceived themselves as being under some external threat, they generally have adopted an expansive interpretation of civil liberties. At those times, citizens tend to believe that the government should interfere as little as necessary in individuals' lives. Accordingly, they strongly support people's right to gather with others and to speak their minds, even when the content of that speech is controversial. When the nation has been under some perceived threat, citizens have often allowed the governments to limit protected freedoms. Make sure you get the gist of those amendments down in your notes. Limits have also extended to many due process protections, legal safeguards that prevent the government from arbitrarily depriving people of life, liberty, or property without adhering to strict legal procedures. In this chapter, we consider not only the historical context of our civil liberties, but also recent changes in how Congress, the President, and the courts interpret these liberties. The framers vividly remember the censorship and suppression of speech that they had suffered under British rule. Colonists had been harshly punished, often by imprisonment and confiscation of their property, and even death, if they criticized the British government, through both speech and publication of pamphlets. The framers understandably viewed liberty as a central principle guiding the creation of new democratic republic. Federalists such as Alexander Hamilton saw the Constitution itself as a Bill of Rights because it delegated specific powers to the national government and contained specific provisions designed to protect citizens against an abusive government. In this table, the protections listed in this table were designed to protect people from being punished, imprisoned, or executed for expressing political beliefs or opposition. However, the Anti-Federalists still stressed the need for a written Bill of Rights. As we talked about earlier this year, the ratification of the Constitution stalled because citizens feared that the government might use its expanded powers to limit individual freedoms, particularly those associated with political speech and engagement. The First Amendment, which ensures freedom of religion, the press, assembly, and speech, was essential to political speech and discourse in the larger society. Maybe you can remember that by the word spare, S-P-A-R-E, speech, press, assembly, religion, establishment clause. The freedoms embodied in the Bill of Rights are broad principles rather than specific prohibitions against governmental action. From the nation's beginnings, the vagueness of the Bill of Rights led to serious disagreement about how to interpret the amendments. For example, the First Amendment Establishment Clause states simply that Congress shall make no law respecting an establishment of religion. Some commentators, most notably Thomas Jefferson, argued that the clause mandated a wall of separation between church and state, and barred any federal support of religion. Others more narrowly interpreted the clause as barring only the establishment of a national religion or the requirement that all public officials swear an oath to some particular religion. This disagreement about the breadth of the Establishment Clause is ongoing today, as courts and lawyers continue to try to determine what the proper relationship should be between church and state. Other freedoms, too, have been subject to differing interpretations, including the First Amendment guarantees of freedom of speech, assembly, and the press. These conflicting interpretations often arise in response to public cries or security concerns. Security concerns also affect the protections offered to those accused for threatening the safety of the nation. For example, the USA Patriot Act, passed by Congress almost immediately after September 11 attacks and amended in 2002, allows law enforcement a good deal of legal leeway. It permits agents to sidestep well-established rules that govern how searches and seizures may be conducted and to restrict criminal due process protection severely, particularly for persons suspected of involvement in organizations thought to have ties to suspected terrorists. Civil liberties advocates worry that fear is causing Americans to give up their most precious freedoms. The framers intended the Bill of Rights to restrict the powers of the national government. They did not see the Bill of Rights as applicable to the states. In general, there was little public worry that the states would curtail civil liberties because most state constitutions included a Bill of Rights that protected the individuals against abuse of state power. Further, it was generally believed that because the state government were geographically closer to the people than the national government, they would be less likely to encroach upon individual rights and liberties. Through most of the early U.S. history, the Bill of Rights applied to the national government, but not the states. That assumption is illustrated in the case of Barron v. Baltimore, 1833, in which a wharf owner named Barron sued the city of Baltimore. Barron claimed that the city had violated the Takings Clause of the Fifth Amendment, which bars the taking of private property for public use without just compensation. Barron argued that by paving its streets, the city of Baltimore had changed the natural course of certain streams. The resulting buildup of silt and gravel in the harbor made his wharf unusable. The case centered on the idea that the Fifth Amendment protects the individuals from actions taken by both the national and the state or local governments. The Supreme Court disagreed, ruling that the Fifth Amendment was restricted to suits brought against the federal government. In 1868, 3 years after the Civil War ended, the 14th Amendment was added to the U.S. Constitution. The 14th Amendment reads as if it were meant to extend the protections of the Bill of Rights to citizens' interactions with state governments. This is what it says. No state, which is different, shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Although this language sounds like an effort to protect citizens' rights and liberties from arbitrary interference by state governments, the Supreme Court rejected the doctrine of total incorporation, that is, the application of all of the protections contained in the Bill of Rights to the states. Instead, beginning with a series of cases decided by the court in the 1880s, the justices formulated a narrower approach known as selective incorporation. This approach considered each protection individually, one case at a time, for possible incorporation into the 14th Amendment and application to the states. In each case, the justice rejected the plaintiff's specific claims of protection against the state. But the court held that due process mandates the incorporation of those rights that serve the fundamental principles of liberty and justice, those that were at the core of the very idea of free government, and that were unalienable rights of citizenship. Despite those early years, the Supreme Court continued to embrace the idea that although citizenship meant being a citizen of a state and of the nation as a whole, the Bill of Rights protected citizens only against the national government. As you see in this chart, not until 1925 did the court gradually begin the process of incorporation, starting with the First Amendment protections most central to democratic government and civic engagement. That year, in the case Gitlow versus New York, the court held that freedom of speech is among the fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by the states. In 1931, in its decision in Neer versus Minnesota, the court added freedoms of the press. And in 1937, it added the freedom of assembly to the list of incorporated protections. Incorporation progressed further with the landmark case of Palco versus Connecticut, in which the court laid out a formula for defining fundamental rights that later courts have used time and time again in corporation cases, as well as in due process cases more generally. The justices found that fundamental rights were rooted in the traditions and conscience of the American people. Moreover, if those rights were eliminated, the justices argued, neither liberty nor justice could exist. Judges in subsequent cases have used this formula to determine which Bill of Rights protections should be applied to the states. In case after case, the justices have considered whether such a right is fundamental, that is, rooted in the American tradition and conscience, and essential for liberty and justice. And they have been guided by the principle that citizen participation in government and society is necessary for democracy, engaging the importance of each constitutionally protected right. Over time, the Supreme Court has incorporated most Bill of Rights protections, as this table summarizes. Among the few notable exceptions to the trend of incorporation are the Third Amendment's protection against the quartering of soldiers in citizens' homes, which has not been an issue since colonial times, the Fifth Amendment provision for a grand jury indictment, whereby a panel of citizens determines whether or not there is enough evidence for prosecutors to bring a criminal case, runs counter to a trend in state criminal cases away from a reliance on grand juries. A grand jury is not required to guarantee that states adhered to Fifth and Sixth Amendment protections during the arrest, interrogation, and trial of criminal defendants. Similarly, the Seventh Amendment provision of a jury in a civil trial is widely viewed as less important than the Sixth Amendment guarantee of a jury trial in criminal cases in which life and liberty may be at stake. The cases that I have checkmarked are the ones that you need to know for the AP and for your test. So that is incorporating the Freedom of Speech Clause of Amendment 1 in Gitlow versus New York, the Freedom of the Press Clause in Amendment 1 in Neer versus Minnesota, the Freedom from Government Established Religion Clause from Amendment 1 in Everson versus Board of Education. I hope you note that the Second Amendment was not incorporated to the states until 2010. That is a common misconception. In McDonald versus the City of Chicago. And then you have no unreasonable searches and seizures in 1949, incorporated to the states in Wolf versus Colorado. The exclusionary rule, which was part of the Fourth Amendment, was incorporated in 1961 in Mapp versus Ohio. And lastly, the right to counsel in criminal cases from Amendment number 6 is in Gideon versus Wainwright. So make sure that you know those cases, plus the ones Barron versus Baltimore and Palco versus Connecticut from this chapter.